All right, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. And good morning, everyone, and welcome to today's remote sitting on the Appeals Court. I'm going to begin by introducing the panel to you. Joining me today is Justice William Meade and Justice Amy Blake, and my name is Ariane Vuono. Next, I want to quickly remind you that each side only has 15 minutes to present their argument, so we suggest you get right to your most important points, and that our rules in the state court do not permit any rebuttal. Finally, upon occasion, but only upon occasion, we do experience some technical difficulties, and if we do, we expect you to be patient with us, and you in turn can be assured that we will be patient with you. So with that said, I'm going to call the first case, which is Commonwealth versus EDUARDO Ramirez, 2020-0079, and Attorney Peterson, please begin.
Good morning, Your Honor. Good morning, Your Honors. Attorney Kim Peterson for Mr. Eduardo Ramirez. May it please the court. This case is, in a nutshell, basically the reputation of the defendant and his bad character was what was addressed, not the credibility of the two witnesses, which was only a police officer and Mr. Ramirez, but rather it became a contest where the Commonwealth basically said, let's look at this defendant's bad character, and that's what this case is going to be about. This struck at the heart of Mr. Ramirez's case. It did not give him an opportunity to have his side basically heard by the jury and listened to, which exactly what Vuono, as well as several other cases, have stated. The defense attorney in this case did a great job. She went over above and beyond objecting, thereby preserving the error. But we would hold that the admission of Mr. Ramirez's prior conviction diverted the jury's attention.
It was just one, right? Operating after suspension.
A subsequent offense. But how it was addressed, Your Honor, is what concerns me the most. During the cross-examination, the Commonwealth stated to Mr. Ramirez, this isn't the first time you were before the court. The defense attorney immediately objected, it was overruled, and then the DA said, in fact, you have prior convictions. And the defendant said, yes, I do. And then it was one such conviction was that in 2015, you were convicted of an operating after suspension. That's correct. There was no curative instruction by the judge immediately after, as there was in Whitman, Pauling, and McGuire, in order to, kind of rectify that situation. There was also the mention of the conviction in closing, in which the prosecutor repeated that this was a case about credibility, and that, Mr. Ramirez's story didn't ring true, and that the police officers did, and therefore you should believe the police officer. Oh, and not only that, he's got this conviction, and this conviction means since he can't abide by the law outside the courtroom, he's not going to listen to the oath and abide by that here. This was a case where there's
that's what priors come in for, to show that he may not abide by the oath in court.
That is true, but again, it struck to the heart of this defendant's case. It was only.
Didn't the prosecutor also argue that his story his version didn't make sense, and that you should believe the police, and that his prior conviction does not mean he's a bad person?
She did say that, but after saying, it's almost like me saying, I'm not wearing a red jacket. It's got black stripes and orange stripes. Oh, but ignore that it's a red jacket. And that's exactly what the closing of the prosecutor did. It went through the credibility and then—
Isn't that how the judge instructed the jury too?
At the very end, the judge should have done a number of things. The judge should have instructed right after that evidence was presented.
Counsel, let me ask you a question just for clarity's sake, because I don't recall. Now, as I recall, the trial counsel did not request a limiting instruction at the time the prior conviction was admitted in evidence. Is that right?
She did not. She asked for it to be stricken.
Okay, and then she also there was no objection to the judge's instruction in the final instructions to the jury regarding the use of how the jury could use the prior conviction.
No, the defendant acknowledges that at the closing, in fact, the judge did it according to the stock standard jury instruction. She did that. But again, there was nothing further. There was nothing further to mitigate. And I understand, the judge did the balancing test. We acknowledge that. But, the OAS second offense didn't go to credibility. And while it was not similar to the crime charge, nor were there other convictions they could have used, because the judge did say, we're not going to use these because she found them to be too prejudicial.
Peterson,
Yes.
The judge, Howard Hogan, she excluded 2 out of the 3. Do you have a case where a judge exercised her discretion in excluding some and only allowing 1, and that this court or the SJC found that was an abuse of discretion?
No. No, Your Honor. No, I haven't. I've found other cases where, and I believe they're cited, that the judge allowed in cases even though they were similar, because there was no other ones that they could use. But in those cases, the court found that it was such overwhelming evidence, because it didn't just go to the defendant had other defenses, basically. The only defense that this defendant had was his credibility. And in that other case, which was...
So are you
Did he get
saying
acquitted
that
of resisting?
I'm sorry. He was acquitted of disorderly. He was found guilty of resisting. Yeah, there was no,
thought it was
nobody came out of
ABP.
their houses and whatnot. So that was found not guilty by the jury. But the cases that I did cite, Your Honor, that is in there were other defenses of the defendant. Our defendant had no other defenses but his credibility. And that's why it was such a blow to his case. That's all he had was
But
his
if
credibility.
you take your argument to the natural end, no one who's has a prior conviction, let me rephrase that. If the only defense of a defendant is his credibility, your argument suggests you can never use a prior conviction to impeach him.
No, Your Honor, because in other cases, they have other defenses.
No, but my question was, if his only defense, as you say here, is credibility, is it your argument that there should be a blanket rule that if the defense is credibility, no prior conviction can ever come in?
No, Your Honor. As a defense attorney and a former prosecutor, I never have blanket rules on anything.
So then
But
what's
this
the
case-
line? Why is it the case here, but not for all cases?
An operating after suspension second offense has nothing to do with truthfulness. And while the case law says
Is that a requirement?
no, but in this case, this is the only other option. This is the only thing, was this OAS second. And in this case and this fact pattern, it just went to the only defense the defendant had. And if we do that balancing test, it becomes unduly prejudicial. The fairness goes out of this. If that's the only conviction that the Commonwealth had that they had to use against him, and not only does the prosecutor during cross say, this isn't the only time you've been before the court. No.
So essentially, Counselor, what I hear you saying is exactly what Justice Blake has brought up, which is in a case such as this, when there's a dual, the jury must determine the credibility of 2 people only, the victim and the defendant, that in those cases, it's always going to be unduly prejudicial to introduce a prior conviction of the defendant.
It's going to be prejudicial. Overdue? No. In this case, the trial judge could have done a curative instruction right afterwards, like in McGuire, like the other ones, in order to mitigate it. As soon as that evidence comes in, that judge could have said, you can listen to that, but this is the only reason you can.
And would your argument be different if that had happened here?
Yes, it absolutely would have been different.
Okay.
It absolutely would have been different, because the curative instruction didn't come till the very, very end of the instruction. If it had
Which
come,
was about maybe half an hour or 45 minutes later, or not even maybe?
I don't know the exact time, Your Honor. It was short instructions. I mean, they had to go through 3 charges, the resisting arrest, the AB and the police officer.
And that followed, the closing arguments, everything happened in the same day.
That's right, correct, Your Honor. And I will note too, part of the instructions at the very beginning, the voir dire questions was, would you believe a police officer over a civilian? And they did weed out that, but there was never anything about the defendant testifies. If the defendant testifies, his testimony is to be regarded as anyone else's. An instruction like that could have helped, or at least leveled the playing field. And that's the only thing Mr. Ramirez is looking for, is a level playing field.
All right.
And if there's no further questions, I'll just rest on my brief.
Yeah, I'll check with the panel. I see no further questions.
Thank you.
Thank you very much for your argument. Well, now we'll hear from Attorney Johnson.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. And in this case, what we're looking at here is whether the judge abused her discretion in allowing this one conviction in for the purpose of impeachment of the defendant. And when we look at all these relevant factors, it's clear that the judge did not abuse her discretion in this case. And the first is whether and arguably most importantly is whether these charges are substantially similar. In the Brown case, there's language that says it's at least difficult, if not impossible, to show an abuse of discretion where the crimes are not substantially similar. And here, that is certainly not the case. The OAS subsequent conviction is certainly not substantially similar to the charges that were against the defendant at this
What
trial.
about the argument that maybe the operating actor could come in, but that the subsequent offense should have been redacted?
I think that also goes to show to the point that the judge did exercise her discretion in this case, because the judge did consider that argument, but nonetheless allowed it in. And I think the fact that the judge excluded the other convictions as well shows that the judge took careful consideration of what was going to be in front of the jury in this case. And in making the decision to exclude other offenses, but allowing in the subsequent portion of this conviction, I think it just goes to show as well that the judge did exercise her discretion in allowing this conviction and carefully considered what information would be in front of the jury in light of the defendant's case as well. And also, I think the point that the judge did exclude these other two offenses goes to the fact that the judge did carefully exercise her discretion in this case, and that this court should not find that she abused her discretion in allowing the one conviction in. And again, this also goes to the point that the judge did conduct the required balancing test in this case. And I think the transcript is clear that the judge did take into consideration both parties' arguments and carefully parse through this information before making the determination that this conviction was going to come in for the purpose of impeachment of the defendant. And as to the judge's instruction, the judge clearly instructed the jury that when this conviction came in, it was solely for the purpose of the defendant's credibility and to help the jury decide whether they're going to believe the defendant's testimony and how much weight to give to it. And this instruction was clear, and even in the Commonwealth's closing, the Commonwealth clearly indicated what the jury's purpose was for considering this prior conviction, and that they should not consider it for the purposes that are not permissible. And if the panel has no further questions, the Commonwealth will rest on its brief.
No, I see no further questions from either member, the members of the panel. Thank you both very much. Your arguments were very helpful. We'll take the case under advisement and we'll get an answer to you as soon as possible.
Thank you, Your Honor.
We're live.
All right, just before we begin, I want to say good morning to both of you and I welcome you to today's remote sitting. I'm going to begin by introducing the panel to you. I'm joined today by Justice William Meade and Justice Amy Blake, and my name is Ariane Vuono. You've both been here many times before, so you each know that there's 15 minutes per side. And you also know, I'm sure, that the panel has read everything you've submitted to us, and so we suggest that you get right to your most important points. But I will remind you, if I may, that sometimes, occasionally, we experience technical difficulties, and if we do, we will be patient with you, and we hope that you will be patient with us. Okay, so with that said, I'll call the second case we have on today, which is Commonwealth versus Eddie Sotto, 2020-0171. Attorney Power.
Thank you, Your Honor, and good morning. Andrew Power for defendant Eddie Sotto. I'd like to begin with some procedural history because it's a little bit complicated. In August of 2019, Judge Forts allowed my client's motion to vacate his guilty pleas. She found that the interdependent pleas were unknowing and that prior counsel rendered ineffective assistance. And that is found at page 57 of the record appendix. Now, that was the correct decision. The Commonwealth then filed a motion to reconsider. Judge Forts allowed the Commonwealth's motion and resentenced my client to 1 day on counts 1 and 3. Now, in doing so, Judge Forts implicitly vacated the 690-day resentence imposed by Judge Brennan in January of 2014, which is found at page 8 of the record appendix. And she restored the original 1-day sentence imposed by Judge Pierce, the plea judge, in November of 2013, which is at page 5 of the record appendix. Now, we agree that the 690-day resentence must be vacated, but the way to do this under Rule 30B is to order a new trial and then allow the parties to start over again without the defective school zone charges. So we're asking this court to reinstate.
Why would the incorrect sentence affect the other counts, the heroin and cocaine with intent?
Because those charges, the drug charges, the underlying drug charges, were indivisible from the school zone charges. Now, the Commonwealth agrees in its brief at page 25 that the sentence on the 2 drug charges and the school zone charges were interdependent. And you can see the interdependent nature of the plea on the tender of plea form at page 17.
But help me out, because I don't understand the prejudice, because the reason he got the 1-day sentence for distributing or intent to distribute heroin and cocaine was he was going to do the mandatory 2 on the school zone. And in the end, the Commonwealth, even though they lost the benefit of him doing 2 years on the school zone because they no-prossed it, he in the end only got a 1-day sentence for intent to distribute heroin and cocaine. That's a pretty good deal as far as my experience shows me.
Yes, but the problem is that neither party negotiated a 1-day sentence at the time of the plea. At the time of the plea, it's evident that the intent of the parties was that this would be an interdependent sentence. And if we look at page 17, we can see that the reason they did the 1-day sentence was because it was wrapped together with the school zone charges.
That's my point.
Yes. So as a matter of law, the school zone sentence couldn't begin until the sentence on the drug counts was completed. So what we have here is a lack of understanding by Mr. Sotto of the consequences of what he was doing by pleading guilty. Now, in Commonwealth versus Williams, this court held that a mistake regarding the direct consequences of pleading guilty undermines the validity of the guilty plea. Now, that's what happened here. That's the prejudice. My client gave up his right.
What was the consequence in Williams?
In Williams, it was, I believe, armed career criminal charges. Originally, he was looking at 3, and because one of them was a Dukin predicate, it was dropped down to 2, or it was 2 and it was dropped down to 1. So he actually,
under Rule 12, those are things the judge has to explain. The consequences the judge has to explain, right?
Or they can, his attorney can explain them, or they're evident on the face of the plea agreement.
So we don't have an armed career criminal circumstance here, right?
Not an armed career criminal circumstance, no, but it is a similar circumstance in that it is an enhanced sentence that's based on something that was later dismissed due to a change in the law.
Right. Which I'm having trouble understanding to be a mistake instead of a change in the law.
Well, the change in the law is based on the timing of the statute. Now, the school zone charges were knocked out by the 2012 school zone amendment. So the change in law occurred in August of 2012 when the legislature reduced the school zone from 1,000 to 300 feet.
But
Now,
no court had said how it was, whether it was going to be applied retroactively until Bradley, right?
Well, it was up in the air until Bradley. Now, an understanding of whether the school zone amendment was prospective or retroactive was essential to an understanding of the plea deal by the parties. Now, in 2013, the summer of 2013, the SJC paired the cases of Bradley and Pagan to decide the issue of retroactivity. That issue was undecided. It was not, it was ambiguous at that point. And I should note, as I did in the motion for judicial notice that I've submitted, that the Commonwealth, in this case, the Middlesex County District Attorney's Office, was a party to Pagan. So they should have been able to foresee that this issue was about to be resolved.
Is this the new crystal ball requirement we're going to impose?
Well, it's not necessarily a crystal ball. I mean, they were a party to the case, and the SJC announced in the summer of 2013 that we're going to decide the issue of retroactivity in this case. So they're
But they
on
didn't know
notice.
how they were going to decide it. I mean,
Right.
I stood at that podium many times arguing cases, and I could think I knew how it's going to come out, but I don't know how it's going to come out. And I don't understand how you can say that the DA's office knew how it was going to come out because they stood at the podium.
I'm not saying that anybody knew how it was going to come out. I'm saying that they couldn't, the DA's office should have been able to anticipate that it was an unsettled issue. And my
Well, what
client,
difference would that have made? What difference would that have made in terms of how the DA handled your case, your client's case?
well, then in my client's case, you see, amendments are presumptively prospective, but that presumption is not absolute. So it was an open question in this case, whether this amendment was going to be prospective or retroactive. Now, obviously, if it was retroactive, the DA wouldn't have structured the deal around the school zone counts, because they would have known that, okay, well, it's not a 1,000-foot school zone, it's a 300-foot school zone. So
and they
it's not gonna be
realized that after Bradley came out and they null-prossed it, and in the end, he got the one-day sentences on two significant crimes. Let me jump ahead. What do you want us to do? Do you want a new trial on the A with intent and the B with intent?
I believe the only way to do this is to do what the judge did in her August 2019 decision, which is to allow a motion to vacate the guilty pleas in their entirety, because they're interdependent, allow the parties to go back to the drawing board. Very likely it will not be a new trial. It will probably be some sort of plea agreement, which
could put your client at a much higher risk.
well, let's look at the options. They could negotiate basically the same sentence, the one-day sentence on
What's their
possession with
incentive?
intent, both counts.
You're giving them now the option to go back to trial. Okay, this is a police officer witness case. My guess is they can put that case together. They have no obligation to offer you any deal. Your client could get sentenced to more time.
That is true, Your Honor. That is a possibility, but that is always a possibility.
And he's willing to take the option of more time?
I would not be here if he weren't.
All right, I just wanted to clear that up.
Okay.
So
I'm assuming that's because of the other consequences he's facing now.
he's facing
yeah.
significant federal sentencing consequences.
Yeah.
Has that not occurred yet?
It can be reopened and readjusted.
Did they readjust his federal sentence to account for the 1 day rather than the 690?
It is still to be determined, Your Honor. The federal consequences are, one, the criminal history points, which are at 3, I believe now, should be at 1 under the sentence that the judge imposed the second time. It's also possible that he could negotiate a reduction in the drug charges to straight possession in exchange for an increase in sentence. Now, that would avoid putting a career offender predicate on his federal record.
You on your second issue on the motion to reconsider, you say was improper.
Yes.
Why can't a judge who's made a mistake reconsider her ruling? And keep in mind that the case you rely on, Demirstarshin, if I'm saying it right, has been abrogated by the SJC and Mora in 2017.
Well, I believe we go back to Audubon Hill, and Charles.
Those are civil cases, right?
Charles was not. Commonwealth versus Charles was a criminal case. But In this case, the Commonwealth's motion, as we've shown, contained no new facts, no new evidence, no new showing of demonstrable legal error in the judge's prior decision. And the Commonwealth really offered no grounds for reconsideration of this case.
The judge would disagree with you. She said she made a mistake and fixed it.
I'm not quite sure what she said, what the mistake was in her prior decision.
I guess I'm still stuck on what difference this would make, because if the motion to reconsider was deemed improper, Ms. Walsh would have filed a notice of appeal from the allowance of the motion to vacate. And we'd still be here, but you'd be writing different colored briefs.
That is true, Your Honor. But the fact is that the motion to reconsider under legal principles should have some new facts, new evidence, and shouldn't be wasting the court's time by making the same arguments that have been made again and again, hearing after hearing, filing after filing. The court considered
did that
this.
happen in this case?
Yes.
Was it filing after filing, hearing after hearing? I think there was just one motion to reconsider in this case, right?
Oh, yes, one motion to reconsider, but the arguments that were raised in the motion to reconsider had been made previously, I believe, in 2 or 3 oppositions filed, I think maybe 3 oppositions filed by the Commonwealth, as well as arguments that were made to the plea judge at a status conference and at the hearing on the motion for new trial.
But on the motion for reconsideration decision, didn't the motion judge say that the flaw was in the resentencing and not the plea itself, and that's why she made a mistake? That vacating the pleas was a mistake?
Well,
and it was a sentencing question?
The argument, what the judge said is the defendant is resentenced to 1 day on counts 1 and 3, the defendant having failed to meet the burden of demonstrating any credible reason to vacate conviction on those counts.
Which to me says the problem wasn't with the plea, the problem was with the sentence, and I'm resentencing.
Now, let's assume that that's what she was saying. How was she able to resentence? It wasn't a motion to revise and revoke. That was time barred anyway. The only thing that was before her was a motion for new trial under Rule 30B. Now, he wasn't incarcerated on this sentence at the time, so it wasn't a Rule 30A motion. It wasn't a Rule 29 motion. The only option available to her really in these circumstances was under Rule 30B, to grant the motion for a new trial, to vacate the conviction, and then to allow the parties to start all over again. The Commonwealth's motion was also time barred. I mean, the motion for reconsideration wasn't time barred, but the remedy, I believe, going back and revising and revoking the sentence, essentially, that's not the way to do it procedurally, at least to my mind.
Before we run out of time, I have some questions on your ineffective assistance claim.
Yes.
Was there an evidentiary hearing on the ineffective claim?
We had a hearing before the judge. It was we presented the documentary evidence to the judge, but we did not have an evidentiary hearing with testimony from counsel.
Did the judge make findings of fact?
There were no findings of fact in her decision.
You make a few assertions of fact in your argument on ineffective assistance, but as you just told me, there was no evidentiary hearing and no findings of fact. So what are we supposed to do with your assertions of fact? Like that your client insisted on being present and your client wanted to know about the negotiations that occurred in his absence. So those are nullities, right?
Well, the insists on being present is not a nullity because my client was not in court for his resentencing. That's apparent from the record. That's undisputed.
No, I'm not saying that he was there. I'm saying your assertion of his claim or desire to be there is an assertion of fact that no judge has made a finding on.
Well, this court can certainly consider it, and it's found in the record in his affidavit.
You don't find facts, Mr. Power. You know that.
But it's in the record, Your Honor, and it was presented to the judge. The fact that she didn't explicitly write a finding of fact doesn't mean that it wasn't presented and considered by the judge.
It was presented. What I'm getting at is since she denied the motion, it's implicit that she did not credit those factual assertions and was not required to credit them.
She was not, and she may not have.
Thanks.
Thank you.
Thank you very much. Attorney Walsh?
Good morning, may it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The defendant's motion to vacate his plea was properly denied because the only error in his case was made at a 2014 resentencing hearing and has no bearing on the underlying plea. The defendant's plea was voluntarily and intelligently made.
What about your brother's argument, though, that the only vehicle to address this is through a motion to vacate?
So that was a contentious issue at the trials and at the hearings, which is why I submitted my motion for reconsideration. So he put that argument forth at both hearings. He said at the 12-12 hearing, he said the only available avenue to correct the record is to vacate the convictions. He claims there's no procedural means to do what the Commonwealth suggests. And it was reported back to me that there was a lot of discussion about, I didn't appear at that hearing, about which rule it could be done under. And that's why I submitted the additional filings, because where the defendant served his one-day sentence, the court no longer even had jurisdiction over him to re-sentence him. Any alteration to his sentence that he had already served is simply null and void. So it's not under a rule. And counsel repeatedly tried to act within the confines of a certain rule instead of looking at the case law showing that where the court didn't even have jurisdiction because he'd served his entire one-day sentence, he simply can't be resentenced. The judge's wording in her motion allowing my motion was, it was worded incorrectly. It says the defendant is resentenced to 1 day. He's not being resentenced to 1 day. The 1 day is being restored to the docket because the court never had any jurisdiction to change that. What Judge Brennan did in 2014 was a legal nullity. So the 1 day simply needed to be returned to the docket. So the defense attorneys claim that there's no mechanism to do this is plainly wrong, and which is why I submitted the motion to reconsider, which has the first heading is the proper remedy for the error is a reinstatement of the original sentence.
And that's how it stands now with the one day sentence.
That's correct.
So I presume, well, let me ask you, in other words, a motion to correct the docket or to actually ameliorate any errors that happened, there would be no time frame for that as far as you're concerned, correct?
There would be no time frame because it is merely correcting the records. But at this point, it has been corrected now. When Judge Forts allowed it, the docket does reflect that it is the 1 day sentence that he was originally given. But again, the 2014 error does not render his initial plea either involuntary or unintelligent. And this court is well familiar with the tests applied, which is coercion, duress, improper inducements for a finding of voluntariness. And it was an intelligent plea when initially made because there was no evidence of a lack of understanding of the charges at the time of the plea.
Are you aware of any cases that would allow for a plea to be voidable on a so-called mutual mistake?
No, the defendant did cite some that he saw being favorable to him, but in fact, those contract principles simply don't hold up. He cites Bridgman for the proposition that if the prosecutor makes a promise, essentially they can't break it. That is not what happened here. He cites Santiago and Williams. Those cases are distinguishable. Santiago says a defendant's reasonable expectations surrounding a plea bargain are protected. His expectation was that he would have a 2-year sentence on his record, which now he doesn't. He got a better bargain than he ever could have gotten. A 1 day sentence on possession with intent to distribute on a defendant with a lengthy record. And as Judge Meade stated, Commonwealth witnesses. We could prove this case again. It was very provable at the time, and there's simply no way the defendant would ever get a better deal than 1 day on 2 possessions with intent to distribute. As I briefly mentioned, there was nothing improper about the Commonwealth's motion to reconsider. The reason that was filed was to address the remedy because it was a contentious issue at the hearing, and because at all 3 hearings, the defendant insisted that the only remedy was to vacate the convictions, which is simply untrue. So that motion did bring a legal error to the court's attention, which is certainly proper. As to the third claim regarding ineffective assistance, the only error was at the 2014 resentencing. There's no basis to vacate anything at the initial plea as not knowing or not voluntary. And his ineffective assistance claim with regard to the motion, the fact that motion counsel, whether she rendered ineffective assistance in 2014, has no bearing on the validity of the underlying plea.
In your brief, though, on page 24, you do say that it was improper to have him resentenced, and we're using that word kind of loosely in this context, that was improper, but that there was no substantial risk. Could you explain that?
So having him resentenced was improper, which is why we need to strike it from the docket and restore the one-day sentence. But that doesn't have any bearing on the knowing and voluntary nature of his initial plea. So the fact that there were errors in 2014, it leads to essentially a record-keeping issue at this point, but it certainly doesn't cast any doubt on the integrity of his underlying convictions.
Mhm.
Are there any questions from the court?
One moment, and I'll see. Justice Meade, Justice Blake. No, I see no further questions.
Thank you. I'll rest on my brief.
All right, thank you both very much. We appreciate your arguments. We'll take under advisement and we'll get an answer back to you as soon as possible, and the entire record. And so we suggest you get right to your most important arguments. Lastly, I want to thank Attorney Stone for participating via phone. He had some technical difficulties this morning. We understand that. We may have some, let's hope not. I don't want to jinx anything during the course of the argument. And if we do, we'll all remain patient until we resolve them. So with all of that preamble, let's start with the timer and let's let Attorney Stone begin his argument.
Very good. Good mornings, Your Honors. My name is Ian Stone. I represent the defendant, Marvin Pompilus. And may it please the court, I would like to start by identifying what I think is the essential catch-all phrase of the human trafficking statute. There's a lot of language in the human trafficking statute, but I think that it is most essentially it means to obtain by any means another person to engage in commercial sexual activity, or an attempt to obtain by any means another person to engage in commercial sexual activity. There's more in the statute that this doesn't catch. The statute talks about lewd performances and pornography, but these don't factor in the case at bar. And there's a provision about profiting by means of somebody else obtaining by any means another person to engage in commercial sexual activity, but that provision doesn't factor in the case.
Attorney Stone, this
yes.
is Judge Blake. Do you agree that ability to control is not an element of the human trafficking statute?
I would say that it is not an element to the extent that it doesn't appear in the language of the statute.
But yet your
However,
sufficiency argument seems to suggest that at least as I understand your argument, and please correct me if I'm wrong, is that there was no evidence of control. So can you explain that to me?
Yes, Your Honor, I would be happy to try. The position of the defense is this, that what is an element in human trafficking is either commercial sexual activity or an attempt to obtain commercial sexual activity. So if both of those, the commercial sexual activity and the attempt to obtain commercial sexual activity, consist of indirect evidence, sort of what people describing generally what happens on back page dates, but where there is no specific description of either a commercial sexual activity or an attempt to obtain it, then the rest of the evidence becomes very, very important. If that particular element is sort of implied, then it becomes very, very important if the defendant didn't control what happened on the dates or didn't create the ads or didn't control all of the money and collect the money. Where
So what's
that
the closest Massachusetts case on that point?
Well, Your Honor, in Commonwealth v. Dabney, they emphasized where the evidence of back page work, etc., was vague. They emphasized these other elements. The ones that I am pointing out are absent. The position that I am taking here with regard to the sufficiency of the evidence is that where an element has to be implied, where essentially it has to be the finder of fact has to think, well, yes, I know what happens on back page dates. If that part of it is going to be implied, then there needs to be concrete evidence that the defendant is at least controlling the back page.
Well, let me ask you about that, right? Because in sufficiency, we're looking at it in the light most favorable. And I'm going to try to put it as succinctly as possible. As I understand the evidence, your client recruited multiple women. He used illegal drugs to entice them. As to some, he transported them to and from hotels. He gave them at least access to the back page advertisement. If you pull any one of those out, that's what I hear you doing, parsing the back page. But collectively, in a totality of the circumstances, why isn't that sufficient, even under Dabney, which talks about enticing and recruiting victims to engage in prostitution?
Well, Your Honor, one of the reasons it's not sufficient is because these efforts that go toward obtaining a back page date don't in themselves go toward obtaining commercial sexual activity. And the women did testify to the effect that that was not always involved. And from the standpoint of the person who is obtaining this, or supposedly obtaining commercial sexual activity, that being the defendant, that was not something that was essential to the defendant. It didn't matter, even under the Commonwealth theory, whether or not commercial sexual activity even took place. I think that delivering the defendant as a participant in advertising women for back page dates with the thought of enabling them then to purchase drugs that the defendant sells doesn't establish the elements for obtaining or attempting to obtain another person to engage in commercial sexual activity. It only...
Mr. Stone, yes. This is Judge Meade. In addition to what Justice Blake said, there's also the evidence that they used the defendant's prepaid Visa card to pay for the back page ad, and that he used his hotel or motel room number for the contact. Why isn't that enabling it?
Your Honor, it seems to me that no matter how it is put, it still comes to be that what the defendant is doing is enabling the conduct of a back page date, and the conduct of the back page date is not something that he controls. Rather, what occurs on the date is not something he controls. So, why
does he have to control it? He just has to enable it.
The reason I say so, Your Honor, is because he's not trying to obtain. He's not attempting to obtain another person to engage in commercial sexual activity. He is attempting to obtain another person to engage in a back page date. And what occurs on the back page date is of no consequence to him. So it is not that he is attempting to obtain this act. Rather, he is simply obtaining a successful back page date.
Doesn't he obtain payment thereafter?
I'm sorry? Yes, with regard to payment thereafter, it does appear that the women, should they have wished, could have used the money to purchase their drugs elsewhere. I don't believe there is a testimony that the defendant required that the money go to him for drugs, and I don't believe there is testimony to the effect that he...
Could the jury not infer that? Was that not a reasonable inference?
Was it reasonable to infer that the women had to purchase drugs from the defendant? I do not believe that there is I do not believe that there is evidence sufficient to demonstrate that CW, for example, would have had to provide the defendant money, would have had to engage in commercial sexual activity in order to comply with whatever plans the defendant had for her.
Well, there was evidence, was there not, that the defendant was making money and intended to make money and hoped to make more money on different occasions?
Well, to the extent that there were jail calls that were recorded where the defendant was saying things to the effect of, I'm going to make money. But the testimony with regard to, from the women, with regard to what they were doing, tended to be, we would do what we ordinarily did and what we were doing before we met the defendant, and we would make use of what the defendant was able to provide. And I think one woman said, I did what I ordinarily did, it was just easier, or something to that effect. And this, with the complete absence of acts by the defendant that would seem to be toward obtaining the necessary element, the commercial sexual activity. Instead, it is rather, it has to be implied that both this is what happens on the dates and that this is what the defendant wanted to have happen on the dates, and that essentially that would be enough if that could be demonstrated. But I don't think it can be demonstrated because I don't think it's true. I think that the defendant was indifferent as to what happened on the dates and was indifferent as to whether they contained commercial sexual activity, but was instead interested in being with women who had money to purchase his drugs. And it did seem they described what they did with the money as purchasing drugs and not so much giving, or not at all to my knowledge of giving the defendant money. The only exception to that perhaps is the cell phone image of SM seeking a better split with regard to the money. So there it did appear that they were splitting money and they were negotiating how much money would come of the back page dates. But otherwise...
Mr. Stone, this is Judge Blake, and I don't know that you can see the clock. You're at about 4.5 minutes. So I was wondering if we could just ask you about the duplicative convictions argument, because as I understand it, no notice of appeal was filed from the ruling on the post-conviction motion, which I believe was about a year after the jury verdict. So can you tell me why you think that's correctly before us?
I believe that it is correct. I don't think there's any question, Your Honor, that if one brings a Rule 30B motion on the basis of ineffective assistance of counsel, and this adds to the record on appeal, then that matter has to be appealed. Or if one brings a Rule 30B motion on there being newly discovered evidence, clearly it would be necessary to appeal that, because otherwise the newly discovered evidence wouldn't be put before the appeals court. But otherwise,
but Mr. Stone, Mr. Stone, this is Judge Meade. I think the question was, what's the effect of you having not filed a notice of appeal?
Right.
Yes, and the effect, Your Honor, is not adding an unnecessary layer of complication with regard to this court, Your Honor, your court, Your Honor, making an interpretation of a statutory provision, something that, had it been appealed, would have been a de novo question in any event.
You agree that no notice of appeal was filed after the denial of the motion for new trial?
I agree with that, Your Honor.
But
and
you are suggesting that we can still consider what the judge did on that ruling in the context of the direct appeal?
No, Your Honor, I'm not. I am raising the direct appeal and the convictions, that are part of the direct appeal, that these convictions remain before you. They occurred at trial. They were not affected by the Rule 30 motion, and they remain before you on direct appeal. And with the same question on review, the surviving convictions, as they would have had, the same standard of review as they would have had had a notice of appeal to the judge's action under Rule 30B. With regard to the convictions that are on direct appeal, they are not affected by the Rule 30 motion. The Rule 30 motion was intended and did succeed in simplifying the appeal, not complicating the appeal. There was no reason to add another layer of review that would have been redundant. There's the defendant's convictions are on direct appeal. They're certainly before you. The issue is whether or not
Attorney Stone, and actually you only have about a minute and a half left, and this is Judge Vuono. So as I understand it, you are saying that those arguments are before us because they're encompassed in the direct appeal.
Yes, they are before the defendant's position that the duplicative convictions violate his right not to be tried twice for the same offense and put in jeopardy. That claim under the Fifth Amendment, a claim of constitutional error directly out of the trial, most assuredly, Your Honor, is before you, and I argued it in the brief. It's a constitutional provision that was violated at the defendant's trial. He has the right not to be put, so that the government doesn't have authority to try a person twice for the same offense. But you
did acknowledge in your brief that Massachusetts has not charged human trafficking as a continuing offense, right?
That Massachusetts has not decided that human trafficking is a continuing offense. As I understand it, the prosecution has discretion to charge bunches of things together, should it wish to, but no court has labeled human trafficking as a. But the reason, if I could say just before my time runs out, why it is so obviously a continuing offense is because both obtaining by any means, the means are potentially continuing, harboring, transporting, enticing, etc., and commercial sexual activity, by its definition, is potentially continuing action. So it is certainly, it seems apparent that where these terms by themselves mean continuing things, the human trafficking statute can be charged as a continuing offense, as continuing conduct.
Attorney Stone, I'm going to have you leave it there. I think you summed up your point about the continuing offense. Your time is up. We gave you a little bit of extra time to finish up. So your time is up, and so I'll ask you to rest on your brief from this point on. Okay.
Thank you very much. Thank you, Your Honors.
Thank you. And before we turn and listen to Attorney Haskell's argument, I neglected to call the case officially for the record. I apologize. The case number is 2019-1413. And we've already, of course, heard Attorney Stone's argument, and now we'll turn to Attorney Haskell.
Thank you, Your Honor, and may it please the court. My name is Eric Haskell. I'm an Assistant Attorney General, and together with another former AAG, I was one of the two AAGs who tried this case in the Superior Court.
Mr. Haskell, before you get into sufficiency, can we start with where we just ended, which is, do you believe that the duplicative conviction argument is properly before us, and if not, why?
We do not believe that it's before the court, and that's because no notice of appeal was filed. As the court knows from our brief, there was jury verdicts, there was a sentencing that resulted in judgments of conviction, and those judgments of conviction indeed were properly appealed in the direct appeal.
Can I ask you this, Mr. Haskell? Mr. Stone didn't put it this way exactly, but why shouldn't we treat these as having been raised for the first time on appeal and then review for a substantial risk, which I think would be a rare circumstance indeed, that if we found one of the convictions to be duplicative, that it would not create a substantial risk?
So I understand what Mr. Stone is saying there. I guess what we would point to, Your Honor, is what authority there is for the approach that we're advocating, which is to treat it as not properly before the court. That's the handful of cases, frankly, mostly unreported, that we.
But defendants raise things for the first time on appeal all the time.
They do, and I guess ultimately what it comes down to, Your Honor, is the orderliness of the appeal process.
Well, but certainly if we hear an appeal, and if we were to determine that there were duplicative convictions, we would be obligated to say something about that.
I'm sorry, Your Honor, say that again?
I said certainly if even if the issue was raised for the first time on appeal, as Justice Meade is pointing out, this is not something we would easily ignore. If we determine that there were duplicative convictions, hypothetically, if we were to determine that, we would have to say so.
I guess the difference between this and the ordinary circumstance where a defendant raises an issue for the first time on appeal is what has been appealed here is the conviction that was never challenged on grounds of double jeopardy or duplicative punishments. We aren't talking about duplicative trials, we're talking about duplicative punishments here. That was never challenged in any form prior to that Rule 30 motion in the summer of 2019. And where the defendant here has appealed from the judgments of conviction, he's now mounting an argument that really is outside of the scope of what was litigated in the Superior Court prior to the judgments of conviction. It's it's a separately appealable event, and in our view, there should have been a notice of appeal filed in order.
What do you mean by a separately appealable event?
So the convictions formed final judgments. Those are obviously appealable, and everything that happened before that gets merged into that judgment and becomes fair game on appeal as long as it's been preserved. The issues raised in the motion for a new trial were only raised in the motion for a new trial. The only reason that's appealable at all is that Rule 30 says that denial of grant of a motion of a new trial is a separately appealable event. That's I think subsection 8 of Rule 30, maybe. And
just
so,
to cut to the chase, does it really matter? In other words, if we were to find that one had to file a notice of appeal, that would just simply mean that should have happened. Someone will say that should have happened and deem it to have happened, and it'd be before us anyway.
Again, our view is that to put the issue before the court, the defendant needed to have filed a notice of appeal. He didn't. Okay. But even going to the substance of that issue, even if the court reaches it, again, with the standard of review that applies for, even with the standard of review that applies to an unpreserved argument of this type, Section 50 supports a unit of prosecution that's thoroughly consistent with the way this case was charged, tried, convicted, and sentenced. And this court can reach that conclusion by looking at the language of the statute, which speaks about discrete occurrences with respect to discrete victims, geared towards commercial sex, which the statute defines as a discrete event. And this court can also find support for that conclusion looking at the purpose of the statute as the SJC has interpreted it in McGee, which is the protection of discrete victims. And that's what we're talking about here.
Do you think, could the Commonwealth have filed this as a continuing offense?
Could it have? I have to
Your
say,
brother cites a case, I think it's from
Oh.
1912, about deriving support cases being charged as continuing offenses. I can't say I've shepherdized the 1912 case, but are you aware of other deriving support cases that treat the facts as a continuing offense?
Sure. So actually, if you do shepherdize the 1912 case, the Parrots, you'll find that it's still good law, and that Section 7, deriving support, does connote a continuing offense. In fact, when the defendant filed his Rule 30 motion in the summer of 2019, we actually conceded a couple of the deriving support convictions as duplicative on that basis. But Section 50 is different. Very different statutory language. It's phrased in different terms. It's been interpreted a different way by the SJC. And so, again, in our view,
are there cases from our court or from the SJC that either interpret the trafficking statute as a continuous offense or say that it cannot be interpreted that way? Is McGee really the only case that kind of dances around the edge of that?
The only case that I'm aware of that speaks directly to unit of prosecution under Section 50 is this court's unreported decision in Dunton, which we append to our brief. And the facts in Dunton actually very closely resembled the facts in this case, where the defendant was convicted for taking a particular victim to multiple places, different hotels over the course of several months. And what this court found there was that that conduct supported the multiple charges of sex trafficking that he was convicted of. So unless there's anything else on the issue of double jeopardy and the unit of prosecution.
Well, just if we could finish and just button this topic up, the issue that it was over different county lines, how does that affect the analysis, if at all?
It doesn't affect the analysis. In our view, as we say in our brief, county lines isn't a factor in determining the appropriate unit of prosecution. But in this case, what the evidence showed, both at the time the defendant was charged and the evidence on which he was convicted, is that he committed at least one of these discrete acts towards each victim he was charged with in each county in which he was charged with the crime. And so even though the presence or absence of county lines doesn't really move the needle, the evidence shows that that these charges were properly supported and properly unitized, I guess is the word.
So does the upskirting case help you or hurt you?
I think the upskirting case helps us because this is the Wasili case. Again, it's a different statute and each statute needs to be interpreted in its own terms. But what the SJC found in Wasili is that the purpose of the upskirting statute was to protect victims. And even though the guy in that case only committed one act by placing the camera in the bathroom once, his conduct hit multiple victims and therefore supported multiple units of prosecution. So I guess, again, unless, are there any more questions about the unit of prosecution issue?
I have one about the sufficiency.
Sure.
Is there direct evidence of commercial sexual activity, or is it all to be drawn by inference from the circumstances?
There was at least one, and I think perhaps two of the victims. I know EB for certain, and perhaps some of the others, testified about what happened on these back page dates. And what they testified was that they frequently involved sex, but not all the time. So there is direct evidence in that respect. Beyond that, there is there's a ton of evidence from which the jury could reasonably infer that these back page dates were all about exchanging sex for money. Not the least of that evidence, well, I mean, start with the back page advertisements themselves. They set a tone and paint a picture that I think any reasonable person would interpret as connoting sex as part of the arrangement. And then move on to the defendant's statements and actions. I mean, he made statements about what was happening on these dates. He described them in his own words as out calls. He, bragged to his girlfriend EB on the jail calls when he found a girl who had her own house, and so therefore they didn't have to continue paying for hotels. He spoke a lot about the money that he was making from this activity and how the girls were working for him. He spoke about supplies. He spoke about condoms and lube. He spoke about the best places for the girls who were working for him to find guys. All of that gave the jury everything it needed to reach conclusions beyond a reasonable doubt about what was happening on these dates.
At bottom, he was convicted of 10 counts of human trafficking.
I believe that's right.
And 7 counts of deriving?
I need to check the statement of the case in my brief, but that sounds right, yes.
Okay.
And again, part of the difference there is several deriving convictions that, again, we conceded on the Rule 30 motion because on analysis, we concluded that they were duplicative. I'd like to touch briefly on the defendant's third argument having to do with that one witness who failed to appear, was brought into court on a capias, and then was held after refusing to testify after she was immunized. And I guess what I want to say on that is under different circumstances, this issue could be something that we're talking about here. The fact that this witness was apparently on the record, according to the statements of her lawyer, apparently experiencing symptoms of drug withdrawal and was sent to jail for a period of a couple days. It's an interesting, challenging question whether there are some limits to the ability of a court to enforce its own authority by sending a contemnor to jail in those circumstances. And I don't mean for our brief or for my remarks here to belittle that possibility. I guess our point on that argument is the way it's been briefed, the way it was preserved in the Superior Court, which is to say it wasn't preserved at all. The way that no record was built on that issue and that witness's particular circumstances, what treatment she may have stood to receive when she was in the House of Correction, the law that the defendant cites, which frankly doesn't fit very well with the facts of this case, all lead us to believe that it really doesn't make out a cognizable appellate argument that gives this court something to decide. So unless there are any questions about that issue or about the final issue, the admission of the grand jury testimony, we are happy to rest on our brief.
All right, let me check with the panel. I don't see any questions from Justice Meade or Justice Blake. I have no further questions, so thank you very much. Thank you both very much for your arguments. Again, Attorney Stone, thank you for participating via phone, and thank you both for participating in this remote platform altogether.
We're live.
Okay, thank you very much. And good morning, counselors. I'll call the case. It's SYNQOR versus Commissioner of Revenue 2019-1695. Before we begin, I'd like to introduce the panel to you. I'm joined today by Justice William Meade and by Justice Amy Blake. And my name is Ariane Vuono. I think you both know that you each have 15 minutes to present your argument, that our rules do not permit any rebuttal. We've had today a couple of occasions where we've had some technical difficulties. We will keep our fingers crossed that we don't have any during this upcoming argument. But if we do, you can be assured we'll be patient with you, and we hope that you'll be patient with us as well. So with that said, let me start with you, Attorney Apjon, and please begin your argument.
Good morning. May it please the court. My name is Nelson Apjon. I'm appearing on behalf of the appellant SYNQOR Inc. here today. Before you is an appeal from a decision of the Appellate Tax Board concerning the proper allocation for purposes of the Massachusetts sales factor of litigation proceeds from judgments and settlements resulting from various corporations violating SYNQOR's patent rights. That decision below should be reversed because the Appellate Tax Board, like the Commissioner, did not look at the nature of the rights enforced against the backdrop of the income-producing activities set forth in the statute by the legislature, but instead created a separate income-producing activity for litigation proceeds by using an evidentiary presumption as a substantive rule of allocation.
Well, I realize that's, yes. Can I ask you, as I understand it, there were sort of, I'm going to say 3 buckets of money as you've delineated them. There's the money, damages from the lawsuit, money from settlement agreements, and royalty payments. Is that right?
That's correct. Okay. The last we call authorization royalties, Your Honor.
Okay. Why wouldn't just the first bucket, damages from lawsuit, why wasn't that properly handled?
It wasn't properly handled because what the Commissioner did is, and I guess the main point I'm trying to make is that they erred as a matter of law in using an evidentiary presumption for a means of allocation, when what they should have looked at is the nature of the rights enforced by SYNQOR in deriving the proceeds. And
when we say, back up for a moment.
Sure.
And follow up on Justice Blake's comment. What does that first bucket of money, if you will, what does that represent? What is the nature of that claim?
That first bucket of money is broken into 2 parts. The first was damages for lost profits. And these are not lost profits that the defendants made, but it's based on an analysis of what for the patent infringement, what sales, additional sales, SYNQOR would have made. In addition, for example, SYNQOR did not have a comparable product to make the sale, there was expert testimony as to what would be a reasonable royalty in that situation for the intellectual property that was used by the defendants illegally. That's the first bucket. Second is just the traditional settlements with the defendants. And the third, the authorization royalties, is a bucket basically that when SYNQOR prevailed at trial, the district court set up a permanent injunction that barred the defendants from selling to their end customers, which led their end customers in a bind because they would basically have to shut down their production lines. They couldn't go forward without getting these components. But the permanent injunction authorized SYNQOR to give permission for certain sales, and that's what it did. It had an agreement with its customer, or not the customers, but the end customers, that they could buy certain parts from the defendants, and that was authorized by SYNQOR. The agreements were made with the end customers and not the defendants, but these agreements were memorialized in emails typically, and the defendants were told that, yes, you can sell these products without violating the injunction to the end customers. The end customers were invoiced for the royalty amounts and paid the royalty amounts. So in our view, those have nothing to do with litigation proceeds and never should have been handled as litigation proceeds. They're no different than any other royalty paid to a patent holder for use of the intellectual property involved with the patent.
So for the first bucket, if that represents income that, but for the infringement, SYNQOR would have had, seems to me that's exactly what this statute is designed to capture.
I think it is designed to capture it, Your Honor, but it's the means of allocation that really is the problem here. What the board did and what the commissioner did below is basically use an evidentiary presumption. If you go to the second sentence of that regulation where it says, a Massachusetts domiciled taxpayer's gross receipts from the enforcement of legal rights, and that's quoted on page 28 of our brief, are presumed to be attributable to Massachusetts regardless of form unless the dispute relates to real or tangible personal property. That, of course, is simply an evidentiary presumption. And as the SJC told us as late as 2018 in the American Honda case, all that does is give basically the burden of production. Once contrary evidence is introduced, that presumption disappears. Massachusetts follows the bursting bubble view of presumptions. So it deals with who has the burden of production, but it doesn't say anything about the burden of persuasion. And that's stated in the Mass Guide of Evidence with respect to presumptions. Here, the commissioner makes a very telling point on page 33 of its brief, or his brief. What they say is that neither the regulation nor any decision provides any guidance of what has to be proved to rebut the presumption. But SYNQOR did not rebut it. And that leads to the question, if you don't know what you're looking for, how do you know it hasn't been presented? How do you know it hasn't been rebutted? The problem is they're trying to use a presumption as allocation. And what you need to do is actually look at the legal rights that are being enforced by SYNQOR to determine how we go to allocate those rights when you look at the statute. For example, the statute deals specifically with licensing of intangibles, which the regulations say include patents. And what the regulations say is that unless you can show the place of use, we're going to presume that the licensee's domicile is the place of use, not the licensor, which would be SYNQOR. And what happens when you look at what they did in this case, when you basically use the presumption as a means of allocation as opposed to an evidentiary rule, you end up with a situation where you can have a Massachusetts domiciled patent holder license the patent to a California domiciled corporation for use in California. Now, under the regulations, that income would not be allocated to Massachusetts for purposes of the sales factor. Same hypothetical, but instead the California corporation does not pay the royalty that's owed under that agreement. The corporation, Mass Corporation, goes to California, recovers a judgment for that royalty, the same exact royalty it should have been paid, and now 100% of that allocation is back to Massachusetts. That's an arbitrary result. And the courts have said time and time again, we will not give deference to an administrative interpretation of its regulation when it leads to arbitrary results, capricious results, or unreasonable results. And you have all three in this situation.
Did the
Instead, if you,
out-of-state tax returns of SYNQOR report this income?
I don't believe it did, Your Honor, because it was reported in Massachusetts, so they weren't going to report it twice.
Would the analysis be different if they had reported it in their out-of-state tax returns?
Not according to the commissioner nor the board below by their analysis. They presumed based on domicile alone that it was all attributable to Massachusetts. And that the legal rights.
But then what is your view if the if we were to agree with you that an abatement is warranted? Would you then amend your other tax returns?
That, Your Honor, I'd have to defer to the company, and I don't know. I don't know. I don't know how that would be handled as a matter of tax lawyer. I'm not a tax lawyer, so, and that's probably abundantly clear at this point. But you know, I deal with presumptions. I understand how presumptions work, but going back and amending out-of-state returns is not something I can answer.
Okay.
Are you aware of a Massachusetts case that has applied the analysis in the Polaroid case?
I'm not, Your Honor, but there's no case in Massachusetts, as the commissioner says on page 33, that applies an allocation analysis when you're dealing with enforcement of legal rights. There's no decision, there's no regulation. And in the past, you know, I understand not looking outside of Massachusetts with respect to tax decisions, but that's typically followed when you have a decision or a specific reg in Massachusetts. In situations where you don't have guidance from a decision or regulation, the board often goes outside of Massachusetts to look how other states handle specific situations. In the Polaroid, both the North Carolina Supreme Court decision and the Board of Enforcement in California, it's basically on all fours. Polaroid had received a large patent judgment against Kodak in that case. It was not a California corporation, but California wanted to look at that to see how we were going to allocate that income with respect to California. And it went through a very detailed analysis with respect to lost profits, how they represent basically the loss of product sales, and how that would be used with respect to the average sales factor during the period of infringement. So, you know, I realize it's not on a Massachusetts case, but you don't have a Massachusetts case. What we would ask for is that the court find that there was an error committed below by simply using the evidentiary presumption as a means of allocation and remanding it back to the Board of Appeals to determine the proper allocation. That's been done before, for example, in the professional Boston hockey case, the SJC did that. And we put forth not only Polaroid, but two other possible means of fairly and reasonably allocating the litigation proceeds in a situation like that. We think Polaroid is the best because it focuses on damages, and courts nationwide, we quoted the Pennzoil case from Oregon, which basically says courts traditionally look at in lieu of what have the damages been awarded to determine the tax treatment for those damages. And that's exactly what the Polaroid case does.
So let me ask you, I mean, this is going to probably be too basic of a question, but you acknowledge, I think, that even if you had successfully rebutted the presumption, the commissioner would still have to do something with these three buckets of money. So under your scenario, and I know you put forward more than one alternative method, but you know, pick your best one. What do you think should have happened to these three buckets of money for purposes of Massachusetts tax?
Sure. All right. Remember what I said about the damages. Lost profits were awarded based on the sales that SYNQOR would have made.
What that's bucket number one, so to speak.
Bucket number one. Part A of bucket number one. But the lost profits were for lost sales. And in the Kodak case, they looked at it as lost sales of camera and film, a portion of which would have been made in California. So what California did is they said to Polaroid, take your average sales factor over that period and use that to proportion the amount of California income for lost sales that will be part of your sales factor. With respect to royalties, it basically took the same position of North Carolina, is that we're going to look at this basically as a legal fiction to compensate the patent holder where there is not a comparable product, and you can treat those the same as lost profits. But even if you didn't do that, if you did it based on the Massachusetts law dealing with income from licensing intellectual property, you would still go to where the who made the payments. You look to where the payments are made, the domicile of the payee, under a regulation by the commissioner that says, if we don't know where that intellectual property was used, we're going to presume it was used where the licensee is domiciled. So you go to the domiciles of the defendants. With respect to the settlement payments, it's the same analysis. What we would say is that those are allocated. You could either allocate it based on Polaroid, but probably you would allocate it based again on the illegal use of SYNQOR's intellectual property. They should have paid a royalty for that and used the a royalty analysis for that instead of just presuming it's all income. Because I think 6 out of 7 of the royalty payments were all payees were all located outside of Massachusetts. In regard to the authorization royalties, I think this should be simply treated as royalties under the commissioner's regulations that you would have for a patent. It's no different than any other patent royalty. The end customers didn't pay for illegal use of that intellectual property looking backwards. What they were trying to do is get authorization to get licenses to get products sold to them going forward. So it wasn't a settlement of any type. It was a typical royalty that any other patent holder would have for licensing its royalties.
Okay.
All right. So if I just can go as to, and what little time I have, is just simply with respect to the improper interpretation of the legal rights regulation. I think what happened is it took some twists and turns from the time of hearing until the time of briefing by the commissioner. But ultimately, the board and the commissioner simply looked at the domicile of the corporation and presuming these would all be allocated to Massachusetts. The legislature in Chapter 63, Section 38F, set forth 3 categories of income producing activities: sales other than that of tangible personal property, the licensing of intangible property, which is most relevant here, and business income derived from wagering receipts. There's no indication whatsoever that the legislature contemplated litigation, arbitration, or settlement as separate income producing activities. And the statutory rule of construction, and when one thing is expressed, it excludes things omitted. I think lends support to that argument. But also, if you combine that with the principles in dental services that the SJC set forth, is that tax statutes are narrowly construed, they're strictly construed. A court will not read into a statute an authority to tax that is not plainly conferred by the statute, and any ambiguity is resolved in the taxpayer's favor. The commissioner's interpretation using the reg to create a separate income producing activity for litigation I think is invalid under the statute itself as unauthorized. And it also produces the inconsistent results, which I talked about, where you make a distinction between the patent that's licensed to a California corporation, you're paid for that patent. The proceeds are considered California proceeds because that's where the California corporation is domiciled and using it. But if I go into California, if you're going to California to collect that royalty that's not paid, then it's all allocated to Massachusetts. That's not, as the commissioner says, a bright line rule. It's a very arbitrary rule. It's a very unreasonable rule. And it's contrary to what the legislature provided with respect, how do you handle licensing proceeds with respect to intellectual property? So I will end there with a short time to go. And again, what we're asking you to do is to reverse decision and remand it to the appellate tax board to take into account the proper allocation of the litigation proceeds and looking at the nature of the legal rights that were enforced, and that the authorization royalties should simply be handled as any other patent royalty would be handled, and not as litigation proceeds. Thank you.
Okay, thank you. Thank you very much, Attorney Upjohn. Okay, so now, as soon as we get the clock reset, Attorney Haskell will hear your argument. Just hold on one moment. All right, please begin.
Good morning again, and may it please the court. My name is Eric Haskell. I'm an assistant attorney general, and in this appeal, I represent the Commissioner of Revenue. If the court thinks about it, what the taxpayer is asking for here is really a remarkable thing. What the taxpayer is asking for is to disregard the plain language of the legal rights regulation and to instead impose on it this self-serving, saving interpretation that, in our view, there's no warrant to impose because the regulation is perfectly valid on its face. What's more—
Can I ask you this, Mr. Haskell? If the taxpayer had received the money as it had intended without the need for a lawsuit, is it true that they would only be taxed to the extent that the patent was used in Massachusetts?
I mean, it would depend on exactly what happened, but what the statute looks for in terms of determining allocation is the income producing activity. What is the income producing activity?
In essence, the commission is punishing the taxpayer because the taxpayer had to file a lawsuit to protect its rights.
I don't think that's right, Your Honor, because it again goes to this distinction. What is the income producing activity? Licensing, sure, is one type of income producing activity. It's going to be treated a certain way under the Massachusetts rules. It's also going to be treated a certain way under other states' rules as well. Litigation, enforcement of legal rights, arbitration, settlement is a totally different activity, and that's appropriate because what the statute says is the gauge of sales of things other than tangible personal property is the income producing activity. Where does the income producing activity take place? And not only is that principle going to be reflected in the Massachusetts rules, it's also going to be reflected in the out-of-state rules as well. And that's one of the core problems with what the taxpayer is looking for here. This self-serving interpretation that really risks a windfall that takes away from Massachusetts the ability to impose its corporate income tax on these proceeds in a way that doesn't allow any other state to do so either.
But in other words, help me out with this, Attorney Haskell, if you will. And that is, if we're talking about these litigation proceeds or receipts, if you will, speaking about them generally, right? And you asked the question that's posed by Attorney Upjohn in his reply brief. In lieu of what were the damages awarded, right? And if you say that in what they were awarded for is these lost sales, right? Then you would be applying, as Justice Blake has suggested earlier, a different rule. In other words, the corporation would only be paying, the sales factor would be calculated differently. But why isn't that a fair and reasonable way to approach this?
Because it asks absolutely the wrong question under the statute. The statute doesn't ask, Chapter 63, Section 38F, doesn't ask in lieu of what were these litigation damages awarded. The statute asks, what is the income producing activity? So let me take a step back and kind of walk through step by step. So to begin with, the statute, Section 38F, says that sales are going to be part of the calculation for the corporate income tax, and it defines sales very broadly. It says sales means all gross receipts. So basically, all the money that's coming in the door counts as a sale. But then you need to figure out what portion of those sales is going to be attributed to Massachusetts and implicitly what portion is going to be attributed elsewhere. That is, how are the 50 states, assuming that a corporation does business in all 50 states, going to slice up the pie of that corporation's sales? And the statute establishes two big overarching rules. It says for sales of tangible property, then it's going to be attributed to in this fashion. It's going to be attributed where the property is shipped or sold to. In sales other than tangible property, then you're going to look to the place where the income producing activity occurs, but the statute doesn't define income producing activity. It falls back on the commissioner to define income producing activity. That's what the commissioner has done through the regulation we're talking about here. And the SJC has approved the commissioner's use of a regulation to do that in the Bruins case. So let's look to the regulation. The regulation needs to figure out what is an income producing activity and how do we figure out where it takes place. And the regulation, consistent with the breadth of the definition of sales in the statute, defines income producing activity broadly. It says any transaction, procedure, operation that results in a separately identifiable item of income. And then the regulation goes through, I think, 8 different types of income producing activities that constitute a sale of something other than intangible personal property. And it lays down a more specific rule for each of those. Again, the SJC approved of the commissioner's use of the regulation to do that in the Bruins case.
And that
Now,
would include funds received from royalties.
I'm sorry, I don't follow you, Your Honor.
In other words, I'm looking at these 3 buckets, and I haven't even asked you if you agree that those are sort of the 3 discrete buckets, but assume from my question that you do. I see the royalty aspect of the settlement differently than I see the other 2 buckets. And you're saying you paint with a broad brush. They're all in because they all stem from a lawsuit. Is that right? The commission doesn't have to drill down and look at what the source of each of these buckets was?
So, Your Honor, I think you're right to put the authorization payments off into a different bucket. There is something a bit different about those. They do need to be analyzed differently.
Okay.
But in our view, the question is, what is being sold there? Is it tangible personal property? Is it something other than tangible personal property? And what is the income producing activity, and where is that activity taking place? Now, I guess at this point we're just talking about the authorization payments. In our view, all the money that came in the door to this taxpayer, other than the authorization payments, falls within the scope of the legal rights regulation. And if the taxpayer wants this court to apply a rule other than what the legal rights regulation says, they have to show that the legal rights regulation is an invalid interpretation of the statute. As we explain in our brief, they can't do that. So that's everything other than the authorization payments. Let's talk about the authorization payments. On those, I think it's important for the court to really look at the agreements that are at issue, and you'll find those starting at page 274 of volume 4 of the record appendix. And there's a lot of them. They go on for probably the better part of 100 pages, but they're all worded similarly. What these agreements are emails from the taxpayer to these, call them end users, the Alcatels, the Ciscos, the Lucents of the world, that want to be able to use infringing products that have already been manufactured by the federal defendants, but the federal defendants have this federal injunction saying, hey, you can't sell those to Cisco and Lucent and Alcatel. And so what these authorization agreements did was, in effect, said, we aren't going to enforce the injunction against you. We aren't going to enforce it against the federal defendants because they're barred otherwise from selling these things to Alcatel and Cisco and Lucent. And we also aren't going to enforce it against Alcatel and Cisco and Lucent. And although Alcatel and Cisco and Lucent weren't parties in the federal case, in a sense, they were part and parcel of the federal case, because as we set forth in our brief, the whole theory of the federal case is that these federal defendants are inducing infringement of the patent by getting Alcatel and Cisco and Lucent to infringe the patent. And so with the authorization agreements, what the taxpayer is doing is saying to both of those groups, the federal defendants and the end users, the Alcatel, et cetera, we aren't going to enforce these legal rights against you, and in exchange, you're going to pay us. That is so closely related to the federal litigation and the rights that are settled through the federal litigation that, in our view, it falls within the scope of the legal rights regulation.
So it's not so much they're received because of the suit. They're received as a result of the suit or the enforcement through the agreements.
I think that's right, if I understood your question, Your Honor.
So I'm not a tax lawyer either.
I'm not sure any of us are.
I wanted to follow up, if I could, on something
Yes,
that
please.
your brother raised, and it's set forth at page 33 of your brief. And you acknowledge that there has not been any decisional law, nothing in the regulations that specify what evidentiary showing is required to rebut the presumption. But nonetheless, you say it hasn't happened here. How do we know that if we don't have a standard against which we measure that?
Sure. So I guess two things. First, we know that because it's a presumption, it needs to be rebutted by evidence. There needs to be evidence to show the decision maker, the appellate tax board, the commissioner, why the presumption ought not apply. And that's part of our quarrel with the taxpayers' argument here. Is part of what they're using to try to rebut that presumption is this other presumption that appears in the licensing section of the regulation. Now, in our view, licensing has nothing to do with any of this, so it's completely an opposite, but they're trying to use a presumption to rebut a presumption, and you need evidence to rebut a presumption. So the second part of my answer to that question is take a look at the presumption in the legal rights regulation. What does it presume? It presumes that litigation-related receipts are going to be attributed to Massachusetts. So what evidence do you need to rebut that presumption? You need evidence that it's attributable elsewhere. I think it's very important.
So amended tax returns in other jurisdictions would be some evidence of that.
Sure. I mean, depending on the tax rules in the other states, that may or may not be dispositive, but that's absolutely the kind of evidence that would be germane to.
Or show that they are not litigation proceeds in some way.
They're not litigation proceeds, and so you're therefore outside of the scope of the litigation or the legal rights regulation in the first place. Some more evidence about the provenance of what was being fought over in the federal litigation. You'll notice there's a carve out in the legal rights regulation and says if the litigation is about property that is located entirely in a different state, then they're going to apply a different rule. If the taxpayer here had put on some evidence, maybe to show that the intellectual property had been developed somewhere other than Massachusetts, I think that would have been germane. But they don't put on any evidence to show that the litigation proceeds ought to be attributed elsewhere. And so that's where we're coming from when we say that the court doesn't need to specify what evidentiary showing is necessary, and the reg doesn't say what evidentiary showing is necessary, but in the absence of evidence to show that it's attributable elsewhere, the showing hasn't been rebutted.
What is the significance of the point that you make in your brief that the taxpayer oversaw the federal case from Massachusetts? Why is that important?
Well, I think that goes to show where the income, again, in the language of the statute, where does the income producing activity take place? The income producing activity is, from the taxpayer's point of view, it's deciding to engage in this litigation, it's managing this litigation, it's making the decisions that are going to control the course of this litigation. There's no evidence that those things didn't take place in Massachusetts, and it's perfectly reasonable for the regulation to presume that those kind of things take place where the taxpayer is domiciled. If it's in Massachusetts, if it's in Massachusetts. If it's elsewhere, then it's elsewhere. And I think that's an important feature of the legal rights regulation not to lose sight of, is that it's even-handed. It doesn't say Massachusetts always wins. It's going to work in favor of the Massachusetts DOR in some cases. It's going to work to the Massachusetts DOR's detriment in other cases. And it sets forth this neutral principle that, where you're domiciled is where we're going to presume the income producing activity takes place unless you give us evidence otherwise, which is what the taxpayer didn't do here. I see that my time is winding down. I'd like to just say a couple quick words about the Polaroid case and the Polaroid method. In our view, the court never needs to get there because the regulatory presumption hasn't been rebutted, and therefore you don't need an alternative method of attributing these proceeds. But if you do, there are several big problems with the Polaroid case. One is that it's based on California law, which lacks a presumption similar to what we have in our legal rights regulation. But even more importantly, maybe, the Polaroid method isn't as authoritative as the taxpayer makes it out to be. In fact, if you look at the footnote on page 47 of the taxpayer's brief, you'll see that there was actually a subsequent decision in which the California Board of Equalization walked back some of the conclusions that it reached in that first 2003 decision. It said that, maybe our decision continues to hold for lost profits damages, but reasonable royalty damages and interest are different, and we aren't so sure that they aren't entitled to a rehearing on those issues. And I think that just underscores the hazard of trying to look through a litigation, look through the complaint, look through the damages, and try to parse exactly what it stood in for. The more appropriate approach, and the one that's consistent with our corporate income tax statute, is what the commissioner has done here, and adopt that presumption for revenue from the enforcement of legal rights.
Okay. So thank you very much. As your time is up, but I will check with the panel to see if there's any additional questions. I see none. I feel like I'm back in law school, which is always a good feeling at times, a challenging one. But thank you both very much for your arguments, and thank you very much for your briefs, which set out the issues before us. I will take the case under advisement, and we'll again just a moment. I believe I've heard that we're live. Am I correct?
Yes, we are live. Yep.
Okay, great. Okay, thank you. And it's still morning, so good morning to everybody. And thank you for being here and participating in the argument via this remote platform today. I'll call the case Department of Children and Families versus Another and Father and Others, 2020-0282. Joining me today on the panel is Justice William Meade and Justice Amy Blake, and my name is Ariane Vuono. As you know, the case is impounded, so we don't expect you to use any of the actual names. Just refer to people by their relationships, if you will. We have time splits that are already set up, so I won't go into that. I just want to forewarn you that we have had a couple of technical glitches today. Let's keep our fingers crossed so we don't have any during this particular argument. But if we do, we'll be patient with you, and we hope that you're patient with us. So that said, let's start. The first attorney who will be speaking for half the time, 7.5 minutes, is Attorney Yanoff. Correct?
Should I begin now?
You represent the mother. Yes, right now.
Thank you. Good morning, Your Honors. My name is Warren Yanoff, and I represent the mother in this case. My argument is going to mostly focus on the child Jay, who has a different father than the appellant father in this case. Basically, there is no reason that mother's rights to Jay should have been terminated. Termination requires two prongs, one of which would be her unfitness, but the second, and as important, is that it needs to be in Jay's best interests, that his rights would be terminated. The judge in this case, and I quote, said, "The children are obviously bonded to mother. The children love their parents and enjoy seeing them at visits. Mother and father bring appropriate activities and food to visits." If you look at the judge's findings, they do not have a rationale why it is not in Jay's best interest to terminate mother's parental rights. We have Jay is being placed with the biological father. Biological father was willing and testified that he was going to give 4 visits a year. The court, for unexplained reasons, only offered 2 visits. In this case, there isn't even an adoption plan with regard to Jay filed by the department. That was just testimony at trial. If you look at the history, and there was good visitation, initially there was 1 visit a week for an hour. That increased to 2-hour visits. And then only because this was in trial was it reduced to 1 hour bi-weekly. Nothing really indicated that visits should not have continued or what the problem was in maintaining that. And if you read the findings are clear that Jay wants to have contact with his mother. That's just very clear. The visits, he goes to her, they want it. There's even testimony that he wished to be with mother instead of father. There are issues.
Mr. Yanoff.
Yes, I'm sorry.
So we're only talking about the best interest because you don't challenge the finding that mother was unfit, or would
At this
you?
time, that would correct.
There was considerable evidence of her drug problems and only brief periods of sobriety. And mother continued to use drugs up and through the time of the trial, didn't seem to understand that her drug use had any negative effect on the children whatsoever, and that she had her addiction under control because she had not yet overdosed. How can having someone like that as a caretaker for a child be in the child's best interest?
Well, Your Honor, based on that theory, every time a case is in probate court where we have a substance abuse or mental health issues, we don't terminate rights. That's why we have a two-pronged test. No one's questioning that she may not be fit to physically take care, but there was no evidence that said her contact with the child wasn't in his best interest, or to the extent that the child was getting benefits from having that contact. In my brief, I cite numerous articles that contact with a biological parent is always in their best interest. And there's just no need. There is a case pending in the probate court. This biological father had filed a modification. The probate court on many occasions deals with these kind of issues. This is not an issue in which we need to remove mother's parental rights. We can restrict her visits. No one's suggesting that. But when you terminate rights, especially at a young age, you're looking at lots of things that can change, especially with substance abuse, where she could easily, over some time, become sober, be a positive force with the child. I think that we have to look at that.
Well, I think the department was trying hard, from what I saw, to get her involved and get her to participate, but she wouldn't sign the releases for the drug screens, and she wouldn't complete the other plans that they had for her. She had antagonistic behavior at the hospital incident, demanding drugs. It's more than just the drugs themselves.
But again, that's only one prong. They still didn't present evidence that it was not in Jay's best interest. They need to present that evidence, and the judge didn't find that these visits, and quite the contrary, were harmful. They seemed to be good. And the judge did allow post-termination visits with that. I do want to take exception, I believe, mostly to the child's group. There's only one case, and all these cases are distinguishable with regard to the court's authority to terminate one parent versus the other. In Zarina, the plan was guardianship, not return to the biological parent. In adoption of Amy, again, it was guardianship with the grandparents. That's a huge difference. Xaviera, there was no post-termination visits. Father had been found unfit, and it was a guardianship case again. In Yancey, it was a very different situation because there were no post-termination visits ordered. Mother, in that case, had stabbed father. DCF was looking to terminate both parents, and DCF wanted to remain the custodial of that child. And in Darien, the plan was adoption, and mother didn't even participate in trial. So, I'm sorry, I don't know. Are you asking a question, Justice?
No.
I'm sorry, because you popped up. I apologize. So those fact patterns are distinctly different, where we have good visits, continued visits. No one's questioning that she didn't comply with the service plan, except for visits. And those visits seem to be beneficial to the child. And I don't know if there's any, I see my time is up.
Your time is up. I'll just check to see if there's any questions for you. There are not. And of course, in all the arguments that you raised in your brief, even those you haven't touched upon will be considered. Okay.
Thank you very much.
You're welcome. All right. So next we have Attorney Campbell for the father. Am I correct?
Yes.
Thank you. You may
All
start.
right, I believe we're still good morning by about 10 seconds. So good morning, may it please the court. My name is Alan Campbell. I represent father in this case, in this appeal. And father is seeking remand with an order allowing or approving his adoption plan of having paternal grandfather adopt the girls. Specifically, father is asking that this court recognize a presumption in favor of kinship placements regardless of who nominates the kinship placement. Massachusetts and federal law already favor adoptive parents that are family members. And although father recognizes that judges are not to apply any artificial weight based on who nominates a potential caregiver, I believe that's Hugo and I believe Dora. However, father's argument isn't that paternal grandfather should be the presumptive resource because father nominated him. It's not about who is nominating, but about who is nominated. And in this case,
Don't we need to look at what the judge found as to the nomination of the paternal grandfather? Right? The judge found that he did not press his intentions to seek adoption. He didn't follow through with what DCF required him to do, including the fingerprinting because of the prior record. He testified he was unaware of mother's issues or even his own son's issues, that the grandfather didn't think mother needed any supervision. If you take all of that collectively, as you say, regardless of who nominated him, why is that clear error?
Well, there's two prongs to this argument, or two aspects of it. The first one is that this court should clearly recognize a presumption that's already hidden in the case law, the federal law, the Massachusetts law, the CMRs. The second half is whether or not the judge abused his discretion. As for the presumption, if this court were to clearly state that presumption, then paternal grandfather would have been presumably or presumptively the caretaker. And then the court would have considered, I guess, in effect, the question of whether or not paternal grandfather was fit, which would be a different scheme than what currently happened. So to switch to what currently happened is that it's essentially based on so-called lack of effort and lack of insight by paternal grandfather. Within a month of the children being removed, paternal grandfather had presented himself as a resource. And then he did so later on. He visited perhaps not as much as the court would have liked, but he certainly visited more than the pre-adoptive parents that were approved, who had met the child only a week before the adoptive worker testified. Paternal grandfather was at the birth of both of the girls. He visited them several times a week up until they were removed. He is a part of their life. They know him. He has his own children. DCF has never been involved in his life in terms of him being his parenting ability being questioned. Even during this trial, he testified that he's taking care of his infant daughter 7 days a week. If DCF and the court felt, and any of the other mandated reporters in the court felt that this was an unfit parent, certainly somebody would have fulfilled their duty as a mandated reporter and filed on him, and nobody did, which really shows that
you could be fit for the purposes of one child and not for the purposes of two more.
Yes, of course. But all I'm really saying is that the court didn't, again, apart from the presumption issue, which would be a different scenario, in the abuse of discretion standard, it's still an abuse of discretion. If you look at the father, he's presented himself early on. He's been there throughout. He has, although he doesn't perhaps have as much resources as the adoptive family that was approved, we don't really know because there's a single finding about the adoptive family that was approved.
Didn't the judge find that he was the paternal father, was willing to leave the children with the mother unsupervised, and he failed to appreciate her drug problem?
If you read his testimony completely, which isn't that long, I would implore the court to do so. that is not a fair reading of his testimony. Father was in a slightly, or paternal grandfather rather, was in a slightly difficult position in this case because he was testifying in two hats. His first hat was he wanted the mother to have custody. The second hat was, if I get custody, I will follow DCF's rules. I will not let the parents have unsupervised access to him. I will not let the parents near them if he's high. And what the court seems to just completely gloss over is this gentleman went to college and to become a substance abuse counselor and was a substance abuse counselor for a number of years. He's trained to spot when people are high and he knows about addiction. So it's
Why
that he
wouldn't
lacks
he
insight.
why didn't he agree to be fingerprinted?
I have no idea why he did not agree to be fingerprinted. However, what I can say is the fact that he didn't get fingerprinted really says nothing about his parenting ability. Had the day before, if we go back
It says something about his desire to play by the rules, though.
Father has been completely effort. What is he hiding by not being fingerprinted? He's been
That's my question, and I think it was the judge's question too. They don't let you. They don't let you take custody even as a foster parent without being fingerprinted.
Right. However, if we go back in time to the day before the children are removed, if mother and father had signed guardianship papers to paternal grandfather, he would have been their guardian. There would have been no fingerprinting necessary. It's a step that's put in because of a federal law that says regards money, basically. Payments, reimbursements, states being reimbursed for foster care payments.
But you're presuming that a judge would have approved the guardianship. A probate court judge would have run the records on all the parties, might very well have ordered drug tests. Just because the parties agree to guardianship doesn't mean it's rubber stamped in the probate court.
But paternal grandfather is not hiding his record. His record came in. He's very open. He had a drug problem decades ago. He had a criminal history a while back. The judge says that his last conviction was 2007 or 2008, but if you read his carry, that was actually a qua for dismissal. So his last conviction is actually even further back than that. I don't believe he has any convictions in Massachusetts. So we're talking about 15 years ago. This gentleman had a drug problem. He's overcome it. This is a perfect person to be raising the children of somebody with a drug problem. He's apart from his college training and his work experience of identifying when people are in substance abuse and trying to get them into counseling and other such things, he's lived it himself. He knows the damage it can do. And there was a question that was asked of him about how will you help the girls with this? And he says something to the effect of, oh, that's not my expertise. You're right, it's not his expertise. That's something that the girls would have to go for counseling for. We know absolutely nothing about the pre-adoptive parents other than they're a biracial family that has a bedroom for each child. That's all we know. Approving that stranger over this gentleman, paternal grandfather, who has been with the children since their birth, seen them multiple times a week, it's an abuse of discretion. And for everything else, since my time has expired, I will rest on my brief.
Okay, thank you very much. And all of your arguments that you raise in your brief will certainly be considered by us. All right, so now we're going to turn to an argument by the department and Attorney Peterson.
Good afternoon, Your Honors. My name is Jim Peterson, and I represent the Department of Children and Families. With respect to one of those last arguments that paternal grandfather is the perfect person to raise children of a substance abuse parent, completely disagree with that. This is a case where paternal grandfather, despite the training that he testified to, despite the jobs that he said he had revolving around this, despite his own issues with them, which as Father apparently argues also is one of those things that makes it easier for him to see these issues, he never saw it. He didn't have any idea that his own son had tested positive for cocaine during the course of this investigation and the entire case. He had no idea that how serious this was. He did not know what mother was using. He had spoken to her, but he said he did it delicately, and he never really pushed her towards any of those things. He was okay with this. In fact, he thought at the time of trial that mother was fit, that the parents were fit. That was his plan. Well, the parents were presenting paternal grandfather as an alternative plan, and his plan was, okay, I'll take them, but that's the fallback. The parents are fit. And that's what makes him not the perfect person in this situation, coupled with everything else that we know from him, the idea that he failed to understand these issues, but that he apparently was willing to allow the parents to watch the kids. In fact, he testified point blank that he was fine with them watching his child, and that even if his son were testing positive, he would let his son, which is father in this case, watch the girls. That was not an issue for him. These are the reasons that the judge found it was not in the girl's best interest to have paternal grandfather raising him. That and the other issues as well, like the fact that, sure, he did present very quickly as a potential resource, but he didn't press it. He would not, he was not willing to get fingerprinted for some reason, which was not explained by paternal grandfather well at the time, even though the department kept that case open for 5 months. It shouldn't, for an extra 5 months, but they kept the case open for 5 months to get him fingerprinted, sent a follow-up, explained this, and he never did it. And it died. He didn't visit. He didn't ask for, he didn't visit often. He did visit the children twice in 2018, I believe. And once, however, he brought his own child or children, I can't recall, that became the center of the visit. And his own son had to tell him, hey, this is about our kids, not yours. And he didn't come after that, even though the social worker told him that if you want grandparent visits, let us know and we'll work on that. And he didn't. He never pressed that. He testified at trial that he was interested, that he was trying to do this. He testified at the end of March. The trial continued for approximately 2 more months. And by the end of May, when the department still had testimony, he hadn't followed through then either. He simply failed to follow through what he testified to. Yes, I still want them. Yes, I'm trying to get them. And he never did. And this after the department did send, and again, the social worker sent a letter with handwritten notes. This is why you were denied before. You have a record. You didn't get the fingerprints. That's what happened before. We're willing to talk to you, but you've got to reach out to us. And here are our numbers, handwritten notes that on the side, who to call and what. And he never did. 2 months during the case, and he never pressed that. Those are really the issues pertaining to paternal grandfather. Pertaining to father, the other child, the boy in this case, Jay, that he was, although neither parent challenges your unfitness, mother's unfitness in particular is relevant to Jay's placement and the termination of her parental rights. Mother doesn't appear to argue with the placement at all. Go with the biological father. In this case, this is Father T, as I'll call him, because this is not the father of the girls, not the father that's the subject of this petition. This is a biological father of one of the child, the eldest boy, Jay. Right. But in this, again, mother's substance abuse issues were the substantial reason for the department's concern at the beginning of this case. All throughout, mother never addressed it. Mother didn't seem to even acknowledge that she had a problem. I think it was Justice Meade had pointed out, or Justice Blake, I can't remember who stated this, that yes, she actually, because she wasn't overdosing or selling her children's things to get drugs, she clearly didn't have a problem. That was her testimony. She was using all throughout. After this case started, it started with.
Can I ask you this? If her rights were not terminated, and Dad's wife wanted to adopt the child, what would be required at that time?
Well, and that's one of the issues. This. And I don't know procedurally, Justice Blake, unfortunately, exactly what does happen in that situation, but it does require a procedure at that stage. And that's a huge issue.
Wouldn't they still have to bring a 210 for termination?
And that's where I'm not clear. Unfortunately, I just don't know enough as to what happens.
But without terminating mom's rights, the child is not freed for adoption. Is that fair?
Exactly. Yes, that's very fair. And that's one of the problems. At this point, Jay is living, at this point being at trial, is living with his father and his father's wife and his father's wife's child, Father T's stepdaughter, and was really part of that family. To integrate him further into that family would be the adoption, free him up for adoption, make him a member of this family, which could not happen. And it is a question as to how easily any of that would have happened, should that happen down the line, because this was an incredibly contentious relationship. Mother did not get along with Father T in any way and acknowledged that at the trial. And there were fights back and forth. If you read the judge's findings about the 51As that were filed prior to this case, and there were several, there's a lot of back and forth between the two of them that occurred. It's a lot of things that weren't supported, and it went forward. But this is a very contentious one. She acknowledged that she did not get along with him, and to not terminate her rights would give the child, in this J, this lack of permanency, this lack of stability, of not knowing, am I just a visitor here in this family, or am I part of this family, or what in this situation? And there was testimony as well that when he did go on visits, although the visits themselves went well, there was testimony that he was lashing out and there was difficulty afterward when he would come back. I believe it was 2 to 3 days, maybe 3 to 4 days before he would get back into his routine and act normal, before he would stop lashing out. So the visits, while they were observed, were okay. It wasn't benign on Jay. He was suffering an effect of this back and forth, and he didn't understand what was happening. He was in therapy, though, for this as well. This is one of the things that Father T was doing for Jay. Another one of the many good things that he was doing, along with actually bringing him in to get his 8 cavities and extensive dental work done, as long as bringing him in to treat the open sores with staph and strep infections on his leg. None of these things that Mother had done, which again, all goes to Jay's best interest, that this permanency and this stability is something that Jay deserved and needed. And the judge saw that. The judge was aware of all of these issues. The judge was perfectly aware that she could have done what Father is asking, or what Mother is asking, to have just left him in the custody of Father T, but not done anything else, and not terminated her rights. But she found it was in Jay's best interest to terminate his Mother's parental rights in this case. But these are actually, if there are no further questions at this point, I think the department would rest on its brief.
All right, I'll check with the panel and see no further questions. Thank you very much for your argument. We'll turn now to Attorney Beal, who represents the children.
Good afternoon. May it please the court, Eric Beal on behalf of the appellee children. I'll just touch on a couple of the issues that have raised questions from the panel. First of all, as to Jay, there certainly is, I think, ample authority, as I cited in my brief, for the proposition, and I don't think that legal proposition is contested here, that this court, and the juvenile court in this case, has the authority to terminate the parental rights of one parent and not the other. I think some of the differences.
Willow says, right? Adoption of Willow.
Yes, Your Honor. And I cited other cases, some of which were Rule 128 decisions, but also stand for that proposition. And here, as some of the other counsel have alluded to, there was good reason for the court to terminate mother's parental rights, and owing to her history of neglect of the children, medically and educationally, and to her contentious relationship with Father T. And Mother testified that, that his Father T's thoughts were disgusting to her. She was telling the children in visits that the goal had changed, suggesting it's something that Father T was quote, doing to her. So these relationship was so
only if it's in the record, but are there provisions for the 3 children to see one another?
Yes, Your Honor. There's a visitation provision, and I have no reason to think that hasn't been happening. So there is legal authority. There were facts in the record. The facts, as found by the trial court here, are uncontested. There's no suggestion that any of the facts are clearly erroneous, as found by the trial court, related to these issues. Related to visitation between Jay and mother, I do not believe that issue is raised in the brief, but certainly there was a post-termination visitation order put in place to maintain that contact. And Father T did testify that he was open to allowing such contact. And then secondly, related to the issue of the paternal grandfather, as I argued in my brief, this is really a factually uncontested issue. I think it's been argued as an issue of law, but as a matter of fact, that's uncontroverted. Grandfather did not pursue the process to become a placement for the girls, and therefore he was not an appropriate placement for consideration for them. And I think, again, related to Jay's situation and the case law that I cited, and as my brother, Attorney Peterson, spoke to, it's very important to promote stability for these children. And certainly termination of mother's parental rights would promote that stability. And although I'm not familiar with the procedure, that there certainly was testimony from Father T that his wife was interested in pursuing adoption, and the termination would facilitate that. If there are and no other questions from the panel, I will rest on my brief at this point. Thank you.
I see no further questions. Thank you. Thank you all for your arguments today. We're cognizant of the fact that these cases are always difficult. We'll take all the issues under advisement and we'll get an answer back to you as soon as we can. Okay.
We are live.
Okay, thank you very much and good afternoon. Welcome to today's remote sitting of the appeals court. The last case we have on our list today is Robert Schomes versus Robert Shenna and others, 2019-0956. So before we begin hearing your arguments, let me introduce the panel to you. I'm joined today by Justice William Meade and by Justice Amy Blake, and my name is Ariane Vuono. Briefly, I'll remind you that you each have 15 minutes to present your argument. Our rules do not permit any rebuttal. You can be assured that we have reviewed everything that has been submitted to us, and therefore we recommend that you get right to your best arguments as soon as you can. Lastly, just to not jinx anything in our last argument today, but we have had a couple of technical difficulties. If we have any during this argument, we ask you to be patient with us, and we assure you we will be patient with you as well. So with that preamble, let's go ahead and hear the first argument. Attorney Mishad, the floor is yours, so to speak.
Thank you, Your Honor. Good afternoon, Your Honors, and good afternoon, Attorney Rourke. I represent the plaintiffs, Robert and Kimberly Schomes. This matter is involves a sale of a piece of property that they purchased for their home. And subsequent to them buying the home, they later learned that there was peat moss, that the home had been built on peat moss, which is unsuitable soil for the structure to sit on without it having constant kind of issues with settlement. The issue.
And the only part of the suit that's remaining is this claim against the seller's broker. Is that right?
That's correct, Your Honor.
Okay. Can you tell me what you just described? I know you say the discovery rule applies, so I want to sort of fast forward to that and ask you to tell me what that date is.
The date is, they purchased the home in July of 2007.
Right, but when do you say they were first on notice?
On August 8th of 2010, well, in early August of 2010, they were considering selling their home, and they had a real estate broker come over and apparently had a meeting and what have you. Eventually, that broker recommended to them that they should get a an expert to look at some cracks that she seemed to think might need to be addressed when they sell the home. So what they did was they contacted a structural engineer named Renee Munier, who came out and did a some sort of analysis of the soil, and I imagine he must have inspected the basement and the foundation as well. And so that was in August of 2010. They filed suit in June of 2013.
So August of 2010 is, in your view, the operative date for purposes of the statute of limitations?
Correct, the discovery, correct.
And with respect to the issues, I think I just saw it only in your reply brief. Do you agree that you're not going forward on the misrepresentation of the size of the structure?
Oh, without a doubt, we're waiving that.
Okay. So what if we disagree with you that the discovery rule would have this action running as of August 2010? You'd agree, at least with the dates that the court and your brother used, that both claims would be out on a statute of limitations basis, right? And that your only remaining argument would be equitable tolling.
Yes, you broke up for a second there, but my understanding is from what you're saying was that should you find that the August 2010 date is not the date that the argument that it tolls, then the equitable tolling would apply.
And was that raised below equitable tolling?
I would have to look, Your Honor. I know that the discovery rule and the misrepresentation issue came up right before motion for summary judgment. There were some depositions in late September, October of 2014, late in the discovery process, and then a motion for summary judgment was filed by the defendants in must have been early November, because we've got the package was filed pursuant to the Superior Court rules in early December. So those issues were raised as a result of 2 to 3 depositions, one of which was Sandra Gardner, which we learned that she had knowledge of this engineering report from Mr. Brosnan, who had been hired by the sellers, the Shennas, to investigate the home because they were having trouble selling it. And the Shennas had lived there for 20 years, and that they apparently never thought there was an issue with any major concerns about settlement. After they retained engineer Brosnan, he advised them that they had to do some corrective work, and he expressed that there'd be more continuing maintenance issues than most homes for that home. Keeping ahead of these requires an alert and well-informed owner. So at that point, the Shennas were on notice, and their real estate broker was on notice. And what's important to note is that in January of, when they were selling it, on January of 2017, Ms. Gardner had put in the MLS listing that there was pitch and floor from settlement. Then later on, it got removed and they got reposted onto MLS. And then the second posting, just settlement, was put in there. And in between that time is when the engineer's report, the Shenna's engineer's report, was received.
Well, what do we do about this though, counsel? Your clients hired a home inspector, someone named Peterson. They waived the opportunity to attend the home inspection, which is certainly their right. And it seems uncontested that your clients received the report in May of 2007. There was descriptions about a whole host of things that needed attention, from the roof to the downspouts, the electrical, and the like. And as I understand it, the home inspector said slanted floors and cracks in the foundation are indicative of a potential structural issue. Advised to contact a structural engineer if you wish to evaluate this further. And that's at Appendix 3, page 35. And then their home inspector testified that, and this is at Appendix 4, page 33, I made notes of the cracks I could see. There's no question that the home had experienced a structural issue to some degree. It was all over the place. So why isn't that date the operative date for purposes of the statute?
Because, Judge, the Tiger home inspector, in his report, what he said that this home had experienced prior settlement, and that if they felt that it was necessary, it says in his report, if you wish to evaluate this issue further, but he stated that he did not believe settlement would be an issue in the future, that the settlement had subsided or come to completion. But that's not what happened. Because the home was built on peat moss, it was going to be a continual settlement that was going to go on for infinity, if you will, based upon both engineers' reports, the Shenna's and the Schomes engineers' report.
And then your client testified at their deposition that they basically saw cracks all over the place throughout the house. Again, all predating the date you've given me of August 2010.
They did see cracks, but at the same time, there were cracks when they bought the place. There were cracks when the Shennas lived there for 20 years. They didn't think it was necessary to go out and get it.
There were certainly additional cracks that would indicate that the problem was not over. As in other words,
well, I don't know that.
If we're to accept your view of Mr. Peterson's report that he's only referring to prior settlement, the additional and the new cracks that were observed would tend to contradict that, right?
No, I disagree. I think that any home, it doesn't matter whether it's, whether you have it for a year or 10 years, cracks can appear. Cracks can appear for many different reasons, whether that's,
in fact, I think a reasonable exercising due diligence, if cracks appear in your home, you wouldn't look into it?
I think it depends on the cracks. It also depends on the age of the home. Cracks can happen for many reasons. Insect infestation, improper design of the home, improper construction of the home. But again, this issue was not related to any of that. It was related to, it was built on unsuitable soil. And so that's the real issue. I don't think that, well, a couple of things. One is this, I believe this is a jury issue, whether or not this date, what's the operative date? And the plaintiff's assertion is that the operative date is when they had an engineer, they hired an engineer because they were told by a professional that they should seek an engineer's advice. They weren't contractors, they weren't real estate people, they weren't engineers.
So they have that information, they don't act on it, but then at both of their depositions, they each testified about observing additional cracks, including in the door frame from July of 08 to the fall of 09. And Mrs. Schomes analogized it to, I take umbrance here, the gray hairs of women, that you find one and there's more to come. And before you know it, you have a fully gray head of hair. It seems to me, even if I agree with you that when they got the report, they thought it was all in the past. After they move in and there's new cracks appearing, I'm struggling with your argument that that doesn't then become the operative date.
There's also, Judge, is that the Shennas had filled cracks. There's evidence that they had filled cracks prior to the time they sold it. Okay. So there's, presumably there's plaster and the walls were also stucco in nature. So they weren't a flat, smooth surface. So whether or not cracks can redevelop, cracks, whether it's plaster or joint compound or whatever was used on these cracks by the Shennas, those things can certainly dry, expand and contract depending on the heat and humidity and dryness, etc. So I believe this is a jury issue because it's certainly not something that any one person can say definitively whether or not somebody should know. I believe a jury should be able to decide this issue. And I would note that the motion judge's decision also seems to be contradictory in that I'm not sure how you can square the decision to find summary judgment in favor of the gardener, yet the other defendants, there was not, statute of limitations was not in their favor. I don't believe that seems to coincide or be, seems to fit there. But again, I believe this is a jury issue. The case law has been outlined in my brief. I can certainly go over a few of the cases that talk about it. But again, the operative date is what's at issue here. And I believe that this is a jury issue to be decided by a jury.
Do you agree that if you did not raise the concept of equitable tolling below, that it's waived?
I don't believe so, but at the same time, I'd like to look into that, Judge, and certainly respond, post argument.
Well, I think this is your opportunity to respond.
I believe it was raised, but I don't.
I mean, your brother raised it in his brief, and in your reply brief, I didn't see a mention of it, so. That's okay.
At this point, we have the record and we will be reviewing it. So there won't be any reason, as far as I can tell, that you need to respond. Okay. Have you finished with your argument then? And then you're resting on your brief for anything
I'm resting,
else?
yes.
Okay. All right. So then we can turn now to Attorney Rourke.
Thank you.
Good afternoon, and may it please the court. Charles Rourke for the defendant appellee Sandra Gardner. Your Honors, we ask that the court affirm the decisions of two Superior Court judges and hold that the plaintiff's claims are time barred by operation of General Law, Chapter 262A and 265A. To answer Justice Blake's questions, equitable tolling was not raised in the trial court. It was not an issue before the trial court, and it should not be considered before this court. Now, in a misrepresentation claim, when the subject is a real estate transaction, the Supreme Judicial Court in Albrecht versus Clifford reaffirmed the well-established principle that the statute of limitations begins to run when the misrepresented fact ceases to become inherently unknowable. And on May 20th, 2007, any misrepresented fact ceased to become inherently unknowable. And we know that because in May 14th of 2007, the plaintiffs visited this property with their broker, and they made observations about the extensive settlement throughout this property. Everyone who testified in this case, and there were many, who entered this house said that the floors were slanted, unlevel, and uneven. In fact, that 80-year-old house was moving towards the right front. The only floor that was not slanted was the porch. And the plaintiffs in their deposition testimony made mention of the fact that they saw the settlement. You couldn't hide it. They noticed immediately when they walked in, and nevertheless, they left that day and submitted an offer. Now, it's 6 days later, as was noted, Volume 3, page 33 is the Tiger Home Inspection Report. And in that report, there are over a dozen areas that are identified as, quote, maintenance, repair, or upgrade is required, not functioning as originally intended, end quote. The plaintiffs don't dispute that they received this document. They don't dispute that they reviewed this document. But the key language is on Volume 3, page 35, where Mr. Peterson says, contact a structural engineer if you wish to investigate this issue further. I would direct the court to Volume 4, page 29, which is Mr. Peterson's testimony, where he says, I'm not a structural engineer, but I told them to get one to determine whether or not the settlement was, quote, active or not, end quote. He then went on to describe all the issues that he observed, issues that he observed with the cracks throughout the property. So there's no question that they are on notice of all of these potential issues in May 20th of 2007. The court need go so far as to accept the plaintiff's argument to determine whether or not the issues were inherently unknowable. What they say is when they went to sell the house in August of 2010, someone told them to contact a structural engineer. They did, they observed problems. Well, in May of 2007, someone also told them to contact a structural engineer. They just simply declined to accept that recommendation and proceeded with the purchase. So whether or not we're talking about the line of cases, Friedman versus Jablonski, the Graveline versus Baybank case, Albrecht versus Clifford, all of them stand for this proposition that the statute of limitations begins to run when the misrepresented fact is either known or through the exercise of due diligence should be known. The plaintiffs did not file suit until over 6 years later on June 27th of 2013. Therefore, the claims are time barred. The other theory that was put forth by the plaintiffs in the underlying case had to do with the seller's statement of property condition. If this court finds that there is no that the statute of limitations does not apply. I would note this with respect to the seller's statement. That was a document that was produced between the time the Tiger Home inspection report was received and the time they purchased the property. And recognizing that reasonable reliance overwhelmingly is a question of fact in almost all cases. If we look at volume 3, page 170, and volume 3, page 228 of the plaintiff's testimony, when they were presented with the seller's statement of property condition, Mr. Schoems testified, I don't even remember seeing this before the purchase and sale. When he asked whether or not he had seen it at all before September of 2014, which was the date of his deposition, he said vaguely. Mrs. Schoems said, whatever is in this seller's statement was of no consequence because I already had a Tiger Home inspection at that time. And it's important to remember when they testified, there were claims already pending against a number of defendants, including their broker. And one of the claims was that there was negligent hiring of Tiger Home inspection. So we've highlighted the Collins case, Mahaney, Kuwaiti, all of those cases discuss as a matter of law where reasonable reliance isn't established. I will say those cases focus on the reasonableness, whereas here we don't even have any reliance, let alone whether or not it was reasonable. Next, in the plaintiff's brief, the plaintiffs bring up the fraudulent concealment. Similar to the equitable tolling issue that was not raised, General Law Chapter 260, Section 12 was not raised against Ms. Gardner as a theory of liability. The plaintiff has the trial record, the court has the trial record. You can see that the fraudulent concealment claim was asserted against their broker. And it's specific in the amended complaint. There's a separate count for fraudulent concealment against Patrick Gallagher and Gallagher Real Estate. This simply was not raised in the underlying case, during the motion for summary judgment stage. It was not before the trial court. So similar to the equitable tolling issue, neither of those were raised against Ms. Gardner at that point. However, if the court does address the issue of fraudulent concealment, I would note that Ms. Gardner was the seller's broker. She never communicated with the plaintiffs. There was no active fraud, which is a requirement in order to establish fraudulent concealment. She never prevented them performing inspections, hiring structural engineers, hiring a roofing specialist, all of the recommendations that were made. She didn't prevent them from doing any of that. So even assuming the plaintiffs get around the statute of limitations, the fraudulent concealment was not pled in the underlying case. Even if it had been, that would also fail. And finally, Your Honors, I would note just briefly on the engineer's report, because there was a focus on that in the underlying case. Procedurally, as you've seen from our brief, that was produced by March of 2014. It was introduced as an exhibit by the plaintiffs during depositions. And when they answered their interrogatories and testified in September of 2014, this engineer's report was the failure to produce it was never a theory of liability against Ms. Gardner. It was never asserted. And I would also note that the report, similar to the Tiger Home inspection report, the plain language does not state what the plaintiffs allege it states. It states that a neighboring property, 33 Woods Road, is built on peat. 29, it doesn't make a decision. It says this could explain some of the settlement, but then it goes on to say it's sufficiently strong and safe for habitation, makes a couple of recommendations of work to be performed, which actually was performed by the Shennas prior to the sale. So even assuming it was properly pled, even assuming that report says what the plaintiffs say it says, this amounts to a bare non-disclosure. The failure to produce that report does not constitute an actionable fraud. And if we look at the Greenery Rehabilitation Group case, the Nye versus Boston Survey Consultants, Switten versus Wittensville, all of those cases that we cited in our brief, bare non-disclosure does not account to an actionable tort or violation of 93A. So with respect to the failure to produce the engineer's report, that also, even aside from the statute of limitations issue, would fail. Finally, the plaintiffs focused on Daly versus Avellino. I just want to point to the court's attention. That was a 128 decision, and it had to do with the stock. It was someone who was a investor, and the issue was whether or not who was handling the investments. In that case, it went to trial, and the defendants focused on a statute of limitations defense, and the trial judge declined to instruct the jury on that defense. and it was reversed. And this court, when it focused on the language of that's a factual issue, it should have been addressed by the jury, that was because that was at trial and it wasn't given to the jury. That's not what we have here. Procedurally and factually, this case is clearly distinguishable. Unless there's anything else, Your Honor, if there's any questions, I would ask that the court affirm the decision of the trial courts, which allowed our motion for summary judgment, and the denial of the plaintiff's motion to amend, and the denial of the plaintiff's motion for reconsideration. Thank you.
All right, I see no questions from the panel. We have your briefs, which explain all the issues very well. And so we'll take the case under advisement and we'll get back to you as soon as we can.